I said I don't want side shoes. You either argue the application, or you withdraw it, or the others argue it, and I make a ruling. Mr. Bosota, we cannot be here. We are paid our salaries as a court. When you are saying that some people have been incited there, and then those people could go on fighting when this court is supposed to resolve their issues. That is one. Or we keep this matter in abeyance. People don't pay revenue because they don't know where the boundary is. And as as the petitioner said the other day, they are not able to provide services because of the boundary issue. As stated in this grounds preliminary objection dated 24th May 2023, I have observed that the IEBC had raised similar objections, but which she has now, by she I mean the IEBC, has now withdrawn, and in a surprise twist of events, decided to support the petition. On the issue of precision, I agree with Mr. Nyoka that the petitioner has complied with the threshold of precision by relying on the appropriate articles when moving the court under the Bill of Rights. These are well particularized incidents of harassment, injuries, and loss of property. The same are well particularized and precisioned. The court is therefore fully and well seized of the matter. On the issue of Article 89, this court has not been invited to alter or review the boundaries of any constituencies, but to have the relevant bodies point out these boundaries. This court derives its authority from Article 162 2B of the Constitution of Kenya 2010. Parliament shall establish courts with status of the High Court to hear and determine disputes relating to the environment and the use and occupation and title to land. The Environment and Land Court number 19 of 2011 is preambled as follows. This is an act of Parliament to give effect to Article 162.2 of the Constitution to establish a superior court to hear and determine disputes relating to the environment and the use of and occupation of and title to land, and to make provision for its jurisdiction, functions, and powers, and for connected purposes. Section 13.2a, C, and D of the Act provides as follows. In exercise of this jurisdiction, under Article 162.2b of the Constitution, the court shall have power to hear and determine disputes, A, relating to environmental planning and protection, climate issues, land use planning, title and boundaries, rates, and you should take note of where I'm emphasizing. Rates, rents, valuations, mining, minerals, and other resources. C, relating to land administration and management. And E, any other dispute relating to environment and land. Of course, any other dispute here means anything that is related to the main objective. Among the issues raised in this petition is who should collect revenues in Keroka town. Such revenue includes rates and rents by the two county governments that have a common boundary on the said town, common border on the said town. The other issue is where the boundary is. I agree with Mr. Bosota entirely that a number of prayers in the petition do not fall under the jurisdiction of this court. In fact, the majority of the prayers in this petition do not fall under the jurisdiction of this court. But the dominant issue is the boundary over which this court has jurisdiction, and also collection of those two sets of revenues, that is rates and rents and also land administration and management in Keroka. Section 3 of the Act provides that the principal objective of the Act is to provide just, expeditious, proportionate, and accessible resolution of disputes governed by the Act, and that the parties and their duly authorized representatives, and I believe here mainly the advocates, shall assist the court to further this overriding objective. Council should therefore help parties to achieve this as soon as is practical.